Imagine a documentary filmmaker finalizing a decade-long project. They insert a 5-second clip from a national news broadcast to establish a historical timeline. The next day, a corporate cease and desist letter arrives, threatening catastrophic financial ruin. Does the filmmaker delete the footage and compromise their narrative, or do they stand their ground? This exact dilemma plays out thousands of times a day across the digital landscape, from independent journalists to online reviewers. The line between protecting original creations and stifling free expression rests entirely on one of the most misunderstood concepts in American jurisprudence. That concept is the fair use doctrine. It is a vital exception within the U.S. Copyright Act that permits the limited use of copyrighted material without acquiring permission from the rights holders. Originating as a common law tradition before being codified in the Copyright Act of 1976, this doctrine acts as a critical safety valve. It ensures that the strict enforcement of intellectual property laws does not accidentally crush the very creativity, commentary, and innovation those laws were originally designed to foster. Without this legal buffer, everyday activities like quoting a book in a literary review, displaying a chart in a classroom, or mocking a political campaign ad would be legally actionable. The doctrine recognizes that new knowledge is rarely created in a vacuum. By allowing citizens to build upon existing works for purposes such as criticism, news reporting, teaching, scholarship, or research, the law directly echoes the free speech protections enshrined in the First Amendment. However, fair use is not a clear-cut rule or a specific percentage of allowable copied content. It is an affirmative defense. This means a defendant must prove to a court that their specific, unauthorized use of a copyrighted work falls within the legal exception. While this exploration is for educational purposes only and does not constitute legal counsel, understanding this defense requires looking at how federal judges apply a highly nuanced balancing test built around 4 distinct statutory factors. The first of these 4 factors examines the purpose and character of the use. Courts look closely at whether the new material is commercial in nature or for non-profit educational purposes. More importantly, they analyze whether the secondary use is transformative. A transformative use does not merely copy the original to serve the same exact purpose. Instead, it adds new expression, meaning, or message, fundamentally altering the source material with fresh aesthetics or insights. If a reviewer takes a scene from a blockbuster movie and adds voiceover commentary explaining the camera techniques, the new video is highly transformative. It serves a critical, educational purpose distinct from the original film's goal of pure entertainment. The more transformative the new work is, the less significance a judge will place on other factors, such as whether the creator is making a profit from their commentary. The second factor shifts focus to the nature of the copyrighted work itself. Copyright law aims to protect creative expression, not raw facts or ideas. Consequently, a court is more likely to grant fair use protections when someone borrows from a factual work, like a biography or a historical text, rather than a highly creative work, like a novel, a pop song, or a fictional motion picture. The third factor measures the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Generally, borrowing a small fraction of a larger piece weighs heavily in favor of the secondary creator. However, judges also evaluate the qualitative importance of the excerpt. If someone takes only a few sentences from a massive memoir, but those sentences reveal the book's biggest, most highly anticipated secret, the court may rule that the borrower took the heart of the work, defeating the fair use claim. The fourth and final factor assesses the effect of the use upon the potential market for or value of the copyrighted work. Courts consider whether the unlicensed use acts as a direct market substitute for the original. If a teacher photocopies an entire textbook to distribute to students, it directly harms the publisher's ability to sell those books. Conversely, a scathing review that uses small quotes might hurt the book's sales by persuading people not to buy it, but it does not serve as a replacement for the book itself. These 4 factors remained somewhat abstract until a defining legal battle forced the Supreme Court to clarify their application in the realm of parody law. In 1989, the rap group 2 Live Crew wrote a song called Pretty Woman, heavily sampling and parodying the classic Roy Orbison hit, Oh Pretty Woman. And the group's management formally requested a license from Acuff Rose Music, the copyright holder, and offered to pay standard royalties. Acuff Rose flatly refused to grant permission. Despite the refusal, 2 Live Crew released the track anyway, leading to a massive copyright infringement lawsuit. The rap group argued their song was a parody, designed to mock the romantic, naive nature of the original Orbison track by contrasting it with stark, degrading urban realities. The lower courts were deeply divided. The Sixth Circuit Court of Appeals ultimately ruled against the rap group, heavily emphasizing the commercial nature of the new song and the blatant sampling of the original bass line. The case, Campbell vs. Acuff Rose Music Inc., reached the Supreme Court in 1994, presenting a critical test for artistic freedom. The justices delivered a unanimous decision that fundamentally altered the landscape of intellectual property. They ruled in favor of Two Live Crew, establishing that a commercial parody can indeed qualify as fair use. The court's opinion, authored by Justice David Souter, brilliantly dissected the first factor of the fair use test. Souter emphasized that parody, by its very nature, demands borrowing from the original work to make its critical point. The rap song was intensely transformative because it provided social commentary and criticism of the original hit. The ruling clarified that commercial intent does not automatically disqualify a creator from fair use protections, ensuring that professional artists and critics retain their First Amendment rights to mock and critique culture. Furthermore, the court addressed the third factor by acknowledging that a parodist must be allowed to take enough of the original work to conjure up the specific object of their ridicule. 2. Live Crew needed the iconic bass line of "Oh Pretty Woman," so listeners would instantly recognize the target of the joke. The justices concluded that taking the heart of the original is often a necessary mechanical step in the creation of a successful parody. The echoes of that landmark decision still resonate profoundly today. The Supreme Court created a robust legal shield for modern creators. Without this precedent, the vast majority of late-night television comedy, satirical news programs, and online critique channels would be paralyzed by the threat of relentless litigation. The ruling proved that intellectual property law could be flexible enough to accommodate biting cultural commentary. As technology advanced into the 21st century, the principles from that foundational case never faded. The rise of user-generated content platforms triggered a tidal wave of secondary creations. Millions of users began uploading reaction videos, video game Let's Plays, and deep-dive video essays. These new formats constantly test the boundaries of the doctrine, forcing courts to continually reassess what constitutes a transformative purpose in a digital ecosystem. In this modern arena, the defense is frequently invoked by digital creators facing automated copyright strikes. Algorithms designed to police platforms for unauthorized content cannot interpret context, irony, or educational intent. They simply detect matching audio or video files and issue takedown notices. This technological reality places the burden squarely on the individual creator to understand their rights and formally assert that their usage is legally justified. Navigating these digital disputes requires a meticulous application of the four factors. A creator producing a movie review must ensure they are using only the necessary amount of footage to support their critique. They must actively transform the clips through editing, voiceover, or on-screen analysis. Simply re-uploading a favorite movie scene with a brief introduction does not meet the transformative standard and risks severe legal penalties. It is vital to recognize that fair use is evaluated on a case-by-case basis. There is no universal safe harbor, no magic duration of video, and no specific number of words that guarantees immunity from an infringement lawsuit. A 3-second audio sample could be deemed infringing if it constitutes the absolute core of a song, while a 3-minute video clip might be perfectly legal if subjected to rigorous, frame-by-frame academic analysis. Additionally, acknowledging the original author or adding a disclaimer that no infringement is intended carries absolutely no legal weight. The law focuses entirely on the substance of the secondary work and its economic impact on the original. Misunderstanding this reality leads countless well-intentioned individuals into expensive legal battles, highlighting the critical need for comprehensive legal literacy regarding intellectual property. Ultimately, the doctrine serves as the indispensable bridge between the right to own one's creative labor and the public's right to participate in a shared cultural dialogue. The framers of the Constitution granted Congress the power to secure exclusive rights to authors and inventors for limited times, specifically to promote the progress of science and useful arts. If copyright law were an absolute monopoly, that progress would grind to a halt. Every time a journalist exposes a corporate memo, a teacher distributes a controversial poem for classroom debate, or a comedian dismantles a popular song, They rely on this delicate legal balance. The doctrine ensures that copyright remains a tool for incentivizing creation, rather than a weapon for censorship. It protects the vibrant, chaotic, and necessary exchange of ideas that defines a free society. The continuous evolution of this legal framework reflects the dynamic nature of human expression. As new mediums emerge and the ways we consume media shift, the courts will inevitably face novel challenges in applying the four factors. Yet the core philosophy remains steadfast. The law must always carve out space for the critics, the scholars, and the parodists who shape our understanding of the world by reimagining the works that came before them.